that. All right. I want to get them charged, and it's time to do it. I'm not going to give them the written charge. We can look at it this afternoon. I'll give it to them in the morning. And my charge is ready to go. So the one thing about the bias toward the parties language I added. So with that, I'm ready to move forward.
On page 4, Your Honor.
I don't have that one. I have my own charge. But about witness attacked, that part, bias, the language, is that what you were talking about?
Yes, ma'am. You just mentioned you had added the language. I was trying to know where you were referring to.
I think it is on your page 4, but it's not mine because my charge is different.
The other issue, Your Honor, is as to counts 2 and 3, the felony murder counts. On page 9 of what we've been provided. It reads, a person also commits a crime of murder when in the commission of a felony. That person is the death of another human being with or without malice. And it goes on to specify the predicate felonies for counts 2 and count 3, which count 2 does require malice, count 3 requires criminal negligence. Our request is that with or without malice, phrase that's in parentheses and pattern charge not be added in felony murder intro because it makes confusion because there in fact does require malice as to count 2. So we simply leave it with there has to be a commission of a felony, and that felony as to count 2 does require malice, and as to count 3 requires criminal negligence. That seems to resolve the confusion the easiest way.
What says the state?
We're opposed to having it removed. The difference between malice murder and felony murder is that for felony murder there is no requirement of showing of malice as defined in the malice murder provision. I think your next 2 charges adequately cover the elements of the underlying offenses, and because I don't think there's any confusion that you have to find the malicious element of cruelty in the first, which is defined very differently than malice in the first 3. Malice murder. I did make a suggestion to the defense that, in the spirit of compromise, if you wanted to add language after with or without malice, comma, unless it's an element of the underlying felony offense as defined by the court. I don't think that's necessary. I think it's kind of surplus language. However, when I made that suggestion, they said they didn't want that. So, having made that decision that they don't want that, I'd ask that you just leave the pattern charges as they are.
I'm going to follow the pattern. Okay. Anything else?
I think you're including what's in parentheses in the pattern then as it stated as you gave it to us. And you may have already corrected down below there counts 2 and 3. The first is counts 2 and 3 in the indictment, and then the predicate felonies should be count 4 and 5 as opposed to count 2 and 3 again.
No, I don't know what you're talking about.
Under the specificity as to count 2 and specificity as to count 3, you then have count 2 and 3. And it reads, if you find and believe beyond a reasonable doubt that the defendant committed the homicide alleged in this preliminary indictment as to count 2 or count 3, at the time the defendant was engaged in the commission of the felony of, you then have count 2 and count 3 again. But it's actually count 4 and count 5 are the actual underlying felonies.
I see.
Following that, you just have counts 4 and 5, where you have repeated what you've already given in count 2 and 3. Our request is that you not repeat it again, just simply say count 2, comma 4, and count 3, comma 5, as opposed to doing it again.
I'm going to repeat it.
And then as to the bottom of that page, that's an issue that we dealt with before. I don't think we'll reserve our objection as we had before. We'll pay that up after the court gives the charge. I did have, as to the overall, if after a testimony and evidence presented to you and to go through the counts of the indictment. You had mentioned to us the other day that you weren't going to have it in writing. You were kind of going to go over that.
But you said you wanted it, so I put it in there.
That's correct. I like it being in writing, but I think what needs to be clear, I presume what you were indicating to us orally, you're going to say what's not here, which is that they can find guilt or not guilt as to any particular count or all the counts or any combination thereof.
I'm going to take them one by one.
And we just don't know what that is until you say it. I guess that's my question, but we'll listen closely, I guess.
Okay.
As to the form of the written charge,
The written charge, I'm not going to give them till tomorrow, and we can have more time to review it, and I can have the benefit of your insights.
we also need to do today.
Yeah, but I'm ready to charge them.
Do you want us to put our objections to what you're not charging at the time, or hold those off till you're done?
Hold off. You know, the traditional way,
Our objections to time, I think.
the traditional way things are done. Anything else? Bring the jury.
All rise for the prayer. Let's go.
Which is my microphone? Which one is for the courtroom? Is this the one for me? Is this the one for me in the courtroom? I guess so. We'll find out. Good afternoon, ladies and gentlemen. You are considering the case of the State of Georgia versus Justin Ross Harris. I'm going to give you a verbal charge at this time, and I'm working on a written charge for you to have in the jury room. Bear in mind also that you will have a verdict form to use when you arrive at your verdicts in the case, and you will have the bill of indictment along with the evidence in the case. Thus, you are considering the case of the State of Georgia versus Justin Ross Harris. The grand jury has indicted the defendant with the offenses of Count 1, malice murder, Count 2, felony murder, Count 3, felony murder, Count 4, cruelty to children in the first degree, Count 5, cruelty to children in the second degree, Count 6, criminal attempt to commit a felony, to wit, sexual exploitation of children. Count 7, dissemination of harmful material to minors. Count 8, dissemination of harmful materials to minors. The indictment reads as follows. State of Georgia versus Justin Ross Harris. General Bill of Indictment 14-3124. State of Georgia, County of Cobb. In the Superior Court of said county, the grand jurors selected, chosen, and sworn for the County of Cobb, to wit, and their names are listed thereafter. Count 1. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse Justin Ross Harris with the offense of malice murder, for that the said accused person in the County of Cobb and State of Georgia, on or about the 18th day of June 2014, did unlawfully and with malice of forethought caused the death of Cooper Harris, a human being, by placing said Cooper Harris into a child car seat and leaving him alone in a hot motor vehicle, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 2. In the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Justin Ross Harris with the offense of felony murder, for that the said accused person in the county of Cobb and state of Georgia, on or about the 18th day of June 2014, did commit the offense of murder when the accused caused the death of Cooper Harris, a human being, while in the commission of a felony, to wit, cruelty to children in the first degree, did maliciously cause said Cooper Harris, a child under the age of 18 years, cruel and excessive physical pain by leaving said child alone in a hot motor vehicle, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 3. And the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Justin Ross Harris with the offense of felony murder, for that the said accused person in the county of Cobb and state of Georgia, on or about the 18th day of June 2014, did commit the offense of murder when the accused caused the death of Cooper Harris, a human being, while in the commission of a felony, to wit, cruelty to children in the second degree, did with criminal negligence cause said Cooper Harris, a child under the age of 18 years, cruel and excessive physical pain by leaving said child alone in a hot motor vehicle, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 4. In the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Justin Ross Harris with the offense of cruelty to children in the first degree, for that the said accused person in the county of Cobb and state of Georgia, on or about the 18th day of June 2014, did maliciously cause Cooper Harris, a child under the age of 18 years, cruel and excessive physical pain by leaving said child alone in a hot motor vehicle, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 5. And the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Justin Ross Harris with the offense of cruelty to children in the second degree, for that the said accused person in the county of Cobb and state of Georgia, on or about the 18th day of June 2014, did, with criminal negligence, cause Cooper Harris, a child under the age of 18 years, cruel and excessive physical pain by leaving said child alone in a hot motor vehicle, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 6. And the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Justin Ross Harris with the offense of criminal attempt to commit a felony, for that the said accused person in the county of Cobb and state of Georgia, between the first day of March 2014 and the 18th day of June 2014, did knowingly and intentionally attempt to commit the crime of sexual exploitation of children in violation of Code Section 16-12-100 of the Official Code of Georgia, in that the said accused did perform an act, to wit, the accused did request minor female under the age of 18 years, provide the accused with a photograph and visual medium involving the lewd exhibition of her genital and pubic area, an act which constitutes a substantial step toward the commission of said crime, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 7. In the grandeurs aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Justin Ross Harris with the offense of dissemination of harmful material to minors, for that the said accused person in the county of Cobb and state of Georgia, between the first day of March 2014 and the 11th day of June 2014, did knowingly disseminate and furnish to a minor female under the age of 18 years printed material containing explicit and detailed verbal descriptions and narrative accounts of sexual excitement and sexual conduct, and which, taken as a whole, is harmful to minors, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 8. In the grandeurs aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Justin Ross Harris with the offense of dissemination of harmful material to minors, for that the said accused person in the county of Cobb and state of Georgia, between the 6th day of March and the 15th day of June 2014, did knowingly disseminate and furnish a minor female under the age of 18 years a photograph and visual image of a portion of the human body which depicted sexually explicit nudity, to wit, a photograph and visual image of a male in a state of undress, so as to expose the male's genitals, and of a depiction of uncovered male genitals in a discernibly turgid state, and which, taken as a whole, is harmful to minors, contrary to the laws of said state, the good order, peace, and dignity thereof. Signed, D. Victor Reynolds, District Attorney. True bill returned September 4, 2014. Ladies and gentlemen, the defendant has entered a plea of not guilty to this bill of indictment. The indictment and plea form the issue that you members of the jury are to decide. Neither the indictment nor the plea of not guilty should be considered by you as evidence. Ladies and gentlemen, the defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with a presumption of innocence in his favor. This presumption of innocence remains with the defendant until it is overcome by the state with evidence which is sufficient to convince you, the jury, beyond a reasonable doubt the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or prove innocence. When a defense is raised by the evidence, the burden of proof is upon the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. A reasonable doubt does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, If you find your minds are wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it is your duty to acquit the defendant. Members of the jury, facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Now, members of the jury, it is my duty and my responsibility to determine the law that applies in this case, and then to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented to you. Then you must apply the law that I am presently giving you in charge to the facts, as you find the facts to be. Your oath requires that you will decide this case based on evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all the testimony of the witnesses and any exhibits submitted during the trial. Evidence does not include the indictment, the plea of not guilty, the opening or closing remarks of the attorneys, or questions asked by the attorneys. Also, it does not include anything that I say to you. Now, direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the question, to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified to you in the light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of you, the jury, to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent on direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you members of the jury to decide. Now, you, the jury, must decide the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. A victim has the right to be present at all criminal proceedings in which the accused has the right to be present. A victim or member of the immediate family of a victim shall not be excluded from any portion of any hearing, trial, or proceeding pertaining to the offense based solely on the fact that such person is subpoenaed to testify, unless it is established that such victim or family member is a material and necessary witness to such hearing, trial, or proceeding, and the court finds that there is a substantial probability that such person's presence would impair the conduct of a fair trial. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits experts to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. When scientific, technical, or other specialized knowledge might be helpful, a person who has such special training or experience in that field is allowed to state an opinion about the matter. But that does not mean you must accept the witness's opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion. Now, in determining the credibility of any witness and any testimony by them in court, you may consider, where applicable, evidence offered to cast doubt upon or challenge the credibility or believability of any such witness. Instances of conduct of the witness in question that may relate to the witness's bias toward a party. In determining the credibility of any witness whose credibility has been cast doubt upon or challenged, as I have described above, and any testimony by him or her in court, you may consider, where applicable, evidence offered to support the credibility or believability of any such witness. This would include lack of bias toward a party, specific instances of conduct of the witness that may relate to the witness's lack of bias toward a party. Now, to impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Now, your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pre-trial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. In assessing the credibility of a witness, you may consider any possible motive in testifying if shown. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. You alone shall decide the believability of the witnesses. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the witness stand and testify and be examined and cross-examined as any other witness. However, the defendant does not have to testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary and whether the defendant was properly advised of his constitutional rights. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestion or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you may also consider to what extent the defendant was informed of his rights as discussed below, if applicable. You may consider the duration and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily given. The burden of proof is upon the state to establish that the defendant's statement was voluntary. By that I mean freely and willingly made. If you do not find that the defendant's statement was voluntary, you may not consider it for any purpose. If you find that the defendant's statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1, the defendant had a right to remain silent. 2, if the defendant chose not to remain silent, anything he said could be used as evidence against the defendant in court. 3, that the defendant had a right to consult with an attorney before any questioning and to have the lawyer present with him at all times during any questioning. And 4, if the defendant did not have money for a lawyer would have been provided for him to represent him before any questioning and to be present with him during questioning. The burden is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given up by the defendant. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find the defendant was properly informed of these rights and that he understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict. You should consider with great care and caution the evidence of any out-of-court statement allegedly made by the defendant offered by the state. You, the jury, may believe any such statement in whole or in part, believing that which you find to be true and rejecting that which you find to be untrue. You alone have the duty to apply the general rules for testing the believability of witnesses and to decide what weight should be given to all or any part of such evidence. The defendant's out-of-court statement that is not supported by any other evidence is not sufficient to justify a conviction, even if you believe the unsupported statement. However, proof by other evidence beyond a reasonable doubt that the crime alleged has been committed may constitute supporting evidence of a defendant's statement, if any, should you so find. The law does not fix the amount of supporting evidence necessary. You must determine whether or not other evidence sufficiently supports a defendant's statement so as to justify a conviction. If you find that there was a statement made by the defendant that was supported by other evidence, the degree of proof necessary to convict is that you be satisfied of the guilt of the defendant beyond a reasonable doubt. Evidence of prior difficulties or lack thereof between the defendant and the alleged victim have been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the alleged victim. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine, but you are not to consider that such evidence for any other purpose. Sometimes evidence is admitted conditionally. That is, although you have been permitted to hear the evidence, it is only admitted, and you may only consider it, if you also find certain required but disputed predicate facts which allow you to consider such evidence. If you do not find the conditions necessary in order to allow you to consider the evidence, then you must disregard it completely, even though you have heard the evidence. The defendant is charged with a crime against the laws of the state of Georgia. A crime is a violation of a statute of our state in which there is a joint operation of an act or omission to act and intention or criminal negligence. Criminal negligence is an act or failure to act which demonstrates a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured thereby. Intent is an essential element of any crime, and it must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. Intent may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Now, whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by statute. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a considerations of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Ladies and gentlemen, every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Now, whether or not you make any such inference or inferences is a matter solely within your discretion as the jury. No person shall be found guilty of any crime committed by misfortune or accident in which there is no criminal scheme, undertaking, or intention, or criminal negligence. An accident is an event that takes place without one's foresight or expectation, that takes place or begins to exist without design. If you find from the evidence in this case that the incident that is the subject matter of this case occurred as a result of misfortune or accident and not as a result of a criminal undertaking or criminal negligence, then it would be your duty to acquit the defendant. When the issue of accident is raised, the burden is on the state to negate or disprove it beyond a reasonable doubt. Any evidence as to misfortune or accident should be considered by you in connection with all of the other evidence in the case. If in doing so you should entertain a reasonable doubt as to the guilt of the accused, it would be your duty to acquit. On the other hand, should you believe from the evidence as a whole that the defendant is guilty beyond a reasonable doubt, you may convict. A person shall not be found guilty of a crime if the act or omission to act constituting the crime was induced by a misapprehension of fact that, if true, would have justified the act or omission. Ladies and gentlemen, venue, by that I mean the crime was committed in Cobb County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the bill of indictment, just as any other element of the offense. Venue must be proved by direct or circumstantial evidence, or both. I want to turn your attention to the bill of indictment. Remember that you will have it with you in your jury room. I want to turn your attention to count 1 of the bill of indictment. I instruct you as follows. A person commits murder when that person unlawfully and with malice aforethought, either express or implied, causes the death of another human being. Express malice is that deliberate intention unlawfully to take away the life of another human being, which is shown by external circumstances capable of proof. Malice may, but need not, be implied when no considerable provocation appears, and when all of the circumstances of the killing show an abandoned and malignant heart. It is for the jury to decide whether or not the facts and circumstances of this case show malice. To constitute murder, the homicide must have been committed with malice. Legal malice is not necessarily ill will or hatred, but it is the unlawful intention to kill without justification, excuse, or mitigation. If a killing is done with malice, no matter how short a time the malicious intent may have existed, such killing constitutes murder. Georgia law does not require premeditation, and no particular length of time is required for malice to be generated in the mind of a person. Malice may be formed in a moment and instantly a mortal wound be inflicted. Yet if malice is in the mind of the accused at the time of the doing of the act or killing and moves the accused to do so, such is sufficient to constitute the homicide as murder. Proof of motive is not essential to constitute the crime of murder. Evidence of motive, if any, is admitted for your determination as to whether or not it establishes the state of the defendant's mind at the time of the alleged homicide. Counts 2 and 3 are the charges of felony murder. Count 2 being felony murder, felony being cruelty to children in the first degree. Count 3 being felony murder, the felony being cruelty to children in the second degree. I instruct you, a person who commits the crime of murder when, in the commission of a felony, that person causes the death of another human being with or without malice. Under the laws of Georgia, cruelty to children in the first degree and cruelty to children in the second degree are felonies. Looking to count 2. A person commits the offense of cruelty to children when that person maliciously causes a child under the age of 18 cruel or excessive physical or mental pain. Malice is not ill will or hatred. For the purpose of this code section, malice means an actual intent to cause the particular harm produced, and by that I mean physical pain, without justification or excuse. Malice is also the wanton and willful doing of an act with an awareness of a plain and strong likelihood that such particular harm may result. Intention may be shown by the circumstances connected with the offense. Then as to count 3, felony murder, with the felony being cruelty to children in the second degree. Cruelty to children in the second degree. Any person commits the offense of cruelty to children in the second degree when such person with criminal negligence causes a child under the age of 18 cruel or excessive physical pain. And criminal negligence is an act or failure to act which demonstrates a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured thereby. If you find and believe beyond a reasonable doubt that the defendant committed the homicide alleged in this bill of indictment as to count 2, which is felony murder, cruelty to children in the first degree, or count 3, felony murder, cruelty to children in the second degree, at the time the defendant was engaged in the commissions of felony cruelty to children in the first degree, and that's set forth in count 4, or cruelty to children in the second degree, which will be count 5, then you would be authorized to find the defendant guilty of murder, whether the homicide was intended or not. In order for a homicide to have been done in the commission of a particular felony, there must be some connection between the felony and the homicide. The homicide must have been done in carrying out the unlawful act and not collateral to it. It is not enough that the homicide occurred soon or presently after the felony was attempted or committed. There must be such a legal relationship between the homicide and the felony so as to cause you to find that the homicide occurred before the felony was at an end or before any attempt to avoid conviction or arrest for the felony. The felony must have a legal relationship to the homicide, must be at least concurrent with it in part, and be a part of it in an actual and material sense. A homicide is committed in the carrying out of a felony when it is committed by the accused while engaged in the performance of any act required for the full execution of the felony. I want to turn your attention to count 4 of the bill of indictment, and that is the charge of cruelty to children in the first degree. A person commits the offense of cruelty to children when that person maliciously causes a child under the age of 18 cruel or excessive physical pain. Malice is not ill will or hatred. For the purpose of this code section, malice means an actual intent to cause the particular harm produced, that is physical pain, without justification or excuse. Malice is also the wanton and willful doing of an act with an awareness of a plain and strong likelihood that such particular harm may result. Intention may be shown by the circumstances connected with the offense. Then count 5 is the charge of cruelty to children in the second degree. And I instruct you, any person commits the offense of cruelty to children in the second degree when such person with criminal negligence causes a child under the age of 18 cruel or excessive physical pain. Criminal negligence is an act or failure to act which demonstrates a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured thereby. Now, I instruct you, ladies and gentlemen, that the fact that I have repeated some charges is not to cause you to call extra attention to those portions of the charge. Repetition, if any, is only done to be clear as to each aspect of the charge. You are not to give undue emphasis to any repetition in the charge, but take the charges all together as a complete statement of the law that applies in this case. Calling your attention now to count 6, attempt. A criminal attempt to commit a felony. And the felony is sexual exploitation of children. And I define for you now attempt. A person commits criminal attempt to commit sexual exploitation of children when, with intent to commit sexual exploitation of children, that person performs any act that constitutes a substantial step toward the commission of the crime of sexual exploitation of children. In defining sexual exploitation of children, I first need to define certain terms for you. As used in Count 6 of the Bill of Indictment, minor means any person under the age of 18 years. Sexually explicit conduct means actual or simulated lewd exhibition of the genitals or pubic area of any person. Visual medium means any photograph or other visual medium. And as to Count 6, it is unlawful for any person knowingly to persuade, induce, or entice any minor to engage in any sexually explicit conduct for the purpose of producing any visual medium depicting such conduct. It is unlawful for any person knowingly to possess or control any material which depicts a minor or a portion of a minor's body engaged in any sexually explicit conduct. I want to call your attention to Count 7 of the Bill of Indictment, the charge of dissemination of harmful material to minors. It is unlawful for any person knowingly to furnish or disseminate to a minor any printed matter, however reproduced, which contains any explicit and detailed verbal descriptions or narrative accounts of sexual excitement and sexual conduct, and which, taken as a whole, is harmful to minors. And I want to call to your attention Count 8 of the Bill of Indictment, unlawful distribution of material to minors. It is unlawful for any person to knowingly to furnish or disseminate to a minor any photograph or visual image of a portion of the human body which depicts sexually explicit nudity, which is harmful to minors. Ladies and gentlemen, if after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant did in Cobb County, Georgia, on or about June 18, 2014, commit the offense of malice murder as alleged in the Bill of Indictment, you will be authorized to find the defendant guilty, and in that event, the form of your verdict would be, we, the jury, find the defendant guilty as to count 1. If you do not believe that the defendant is guilty, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, and in that event, the form of your verdict would be, we, the jury, find the defendant not guilty as to count 1. Turning to count 2, felony murder. If after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant did in Cobb County, Georgia, on or about June 18, 2014, commit the offense of felony murder as alleged in the Bill of Indictment, you would be authorized to find the defendant guilty, and in that event, the form of your verdict would be, we, the jury, find the defendant guilty as to count 2. But if you do not believe the defendant is guilty, or you have any reasonable doubt as to his guilt, then it would be your duty to acquit, and in that event, the form of your verdict would be, we, the jury, find the defendant not guilty as to count 2 of the Bill of Indictment. Turning to count 3 of the Bill of Indictment. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant did in Cobb County, Georgia, on or about June 18, 2014, commit the offense of felony murder as alleged in count 3 of the Bill of Indictment, you would be authorized to find the defendant guilty, and the form of your verdict would be, we, the jury, find the defendant guilty as to count 3. But if you do not believe the defendant is guilty, or if you have any reasonable doubt as to his guilt as to count 3, it would be your duty to acquit the defendant, and the form of your verdict would be, we, the jury, find the defendant not guilty as to count 3 of the Bill of Indictment. Turning to count 4, If after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant did in Cobb County, Georgia, on or about June 18, 2014, commit the offense of Count 4, cruelty to children in the first degree, as alleged in the bill of indictment, you will be authorized to find the defendant guilty, and the form of your verdict would be, we, the jury, find the defendant guilty as to Count 4, cruelty to children in the first degree. But if you do not believe the defendant is guilty, or you have any reasonable doubt as to his guilt, it is your duty to acquit, and the form of your verdict would be, we, the jury, find the defendant not guilty as to Count 4. Turning our attention to Count 5, cruelty to children in the second degree. If after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant did in Cobb County, Georgia, on or about June 18, 2014, commit the offense of cruelty to children in the second degree as alleged in the bill of indictment, you will be authorized to find the defendant guilty, and your verdict would be, we, the jury, find the defendant guilty as to Count 5. If you do not believe the defendant is guilty, or you have any reasonable doubt as to his guilt, it is your duty to acquit, and the form of your verdict would be, we, the jury, find the defendant not guilty as to Count 5. Count 6, criminal attempt to commit a felony to wit, sexual exploitation of children. If after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant did in Cobb County, Georgia, on or about June 18, 2014, commit the offense of criminal attempt to commit a felony to wit, sexual exploitation of children, as alleged in the bill of indictment, you will be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty, or you have any reasonable doubt as to the defendant's guilt as to Count 6 of the bill of indictment, it would be your duty to acquit. Your verdict would be, we, the jury, find the defendant not guilty as to Count 6 of the bill of indictment. Count 7 is dissemination of harmful material to minors. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant did in Cobb County, Georgia, on or about June 18, 2014, commit the offense of dissemination of harmful material to minors, as alleged in Count 7 of the bill of indictment, you will be authorized to find the defendant guilty, and in that event, the form of your verdict would be, we, the jury, find the defendant guilty as to Count 7 of the bill of indictment. If you do not believe the defendant is guilty, or you have any reasonable doubt as to his guilt as to Count 7 of the bill of indictment, it would be your duty to acquit, and your verdict would be, we, the jury, find the defendant not guilty as to Count 7 of the bill of indictment. Turning to Count 8 of the bill of indictment, dissemination of harmful material to minors. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant did in Cobb County, Georgia, on or about June 18, 2014, commit the offense of dissemination of harmful material to minors, as alleged in Count 8 of the bill of indictment, you will be authorized to find the defendant guilty, and your verdict would be, we, the jury, find the defendant guilty as to Count 8 of the bill of indictment. If you do not believe that the defendant is guilty, or you have any reasonable doubt as to his guilt as to Count 8 of the bill of indictment, it would be your duty to acquit, and in that event, the form of your verdict would be, we, the jury, find the defendant not guilty as to Count 8 of the bill of indictment. Ladies and gentlemen, by no ruling or comment that the court has made during the progress of the trial, has the court intended to express any opinion about the facts of this case, upon the credibility of the witnesses, about the evidence, or upon the guilt or innocence of the defendant, as these matters are all reserved exclusively for you, the jury. Your verdict should be a true verdict based upon your opinion of the evidence according to the law, as I am giving you in charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party, In deciding this, you should not be influenced by sympathy or prejudice. You are only concerned with the guilt or innocence of the defendant. You are not to be concerned and not to concern yourself with punishment. Now, one of your first duties in the jury room will be to select one of your number to act as your foreperson. Bear in mind, your foreperson will preside over your deliberations and sign the verdict to which all 12 of you freely and voluntarily agree. Start your deliberations with an open mind, as I've told you. Consult with one another. Consider each other's views. Each of you must decide the case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you become convinced that your opinion is incorrect. But you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of other jurors. Now, the notes that you have are for your use only and are not to be shared with anyone until you begin deliberations, and at that point, then you may share them. Bear in mind, notes are not evidence. They are only memory aids, and they should not take precedent over your recollection. It is the duty of each juror to recall the evidence, and while you may consider another juror's notes to refresh your memory, you should rely on your own recollection of the proceedings. Do not be influenced by the notes of other jurors unless their notes help you in determining your own independent recollection. Notes are not entitled to any greater weight than the recollection or impression of each juror as to what the evidence may have been. Whatever your verdict is, it must be unanimous, and by that I mean agreed to by all of you. The verdict must be in writing and signed by one of your members as foreperson. It must be dated and returned to be published in open court. Ladies and gentlemen, 4 of you are alternate jurors. I want you to hold your hand up when I call your names. You will have with you a verdict form that I have prepared for your use in the jury room. It correlates to the bill of indictment. I want to explain to you how to use it. I'm going to hold it up. I know you can't read it from there, but I'm going to point it out, and I think you'll understand where I'm going with it. It consists of 3 pages. The first page has what's called the style of the case, and the style of the case is the Superior Court of Cobb County, State of Georgia. Then it has the style of the case being the State of Georgia versus Justin Ross Harris, defendant, case number 14-93124. And then the bold words, verdict form. Then after that are an entry for each of the counts of the bill of indictment. As to the first count, count 1, malice murder, it reads, we the jury find as follows, count 1, malice murder. As to count 1, we find the defendant blank, this blank day of November 2016. Your verdict will be either guilty or not guilty. Whichever phrase is appropriate is to be written in this blank, dated, signed by your foreperson. Have the same entry for all the other counts. You will have a same entry for count 2, felony murder. You will have an entry for count 3, felony murder. Count 4, cruelty to children in the first degree. Count 5, cruelty to children in the second degree. Count 6, criminal intent to commit a felony, to wit, sexual exploitation of children. Count 7, dissemination of harmful materials. harmful material to minor. Count 8, dissemination of harmful material to minors. As to each of those, when you arrive at a verdict, be it guilty or not guilty, insert the appropriate phrase into the appropriate count. Write out whatever the verdict might be as to each count, date it, sign it by your foreperson. I'm going to excuse you to your jury room, but take no action whatsoever until you receive the indictment, verdict form, and the evidence that's been submitted for your consideration.
All rise for the jury, please. Please watch yourself going down.
Please. Big question.
Officers, y'all just stand off to the side, okay? Please be seated.
I'm inclined to let them go home and bring them back at 8:30 and us finish up our work. Is there a problem with that for the state?
No, Your Honor.
Is there a problem with that for the defense? I'm not going to drag them back in right now. They probably want to, refresh themselves, shall we say. So let's take a few minutes. State's exceptions to the court's charge.
No exceptions, Judge, particularly since you're going to send out a written charge. I did note a couple of things that
Sure.
I wanted to bring to your attention to assist you to prepare that written charge overnight.
Well, we can talk about that in a minute. Exceptions to the court's charge by the defense.
I commend the court for your clarity for doing that for nearly an hour without any noticeable break. And first time I've seen that sometime, so that's noteworthy. On page 7.
But now we hear about it.
But ultimately, we're all human and we all make mistakes.
But remember, I don't have the pages, so you're going to have to give me more detail.
This is the definition of what a crime is. Top of page 7 of mine, before intent, after
Yeah.
submission of evidence. As I heard it, and we can just double check the record, as you indicated, as you read that, a crime is a violation of the statute of this state, which there is a joint operation of an act or omission to act, or intention or criminal negligence. Of course, it should be an intention or criminal negligence, which is the point that we made in our closing. So I'm just asking we double check that. As I heard it, I heard, or I may be mistaken, but that is a very integral part of that definition.
If I had a slip of the tongue and made a mistake there, and we can find out, we'll bring it back in the morning and I'll tell them. Or call their attention to the charge or something along those lines. We can agree how to do that. Let's double check the record first, though, before we do that. In terms of editing what I'm going to send to the jurors, as far as I'm concerned, you've got written copies. Why don't you write on them and submit them to me, and before we leave, and then I can look at them overnight and figure it out, and then we talk about it in the morning. And then that way you're not so pressed for time. Or let me bring them in, let me send them on, and then we can discuss how to do that. Kathleen, have you looked to see? Had a chance? Did you? Well, okay, no problem. I thought you might have been. Let's send them on home. What else?
I had to put my other objections to.
Oh, I thought you were through.
No, ma'am. We also would continue in reviewing our objections if they would give the defense charges 6 through 9 regarding lesser included as a vehicle of homicide, defense charges 10 through 12 regarding lesser included of involuntary manslaughter, charges 13 and 14 regarding lesser included as to contributing to the deprivation of a child. Also, defense charges 1, 3, and 4 regarding criminal negligence and further definition of criminal negligence as we had indicated. And then lastly, the state charge, and the court's ultimate charge regarding statute 16-12-100. Again, reviewing our objection to the charges given as it does not track the allegation of the indictment.
I'm sorry, I thought you were through, so I apologize for that. Let's send them home, and then we'll discuss next steps. How about that? Bring them in, please. And if they have, if they're still, whatever, and let me know.
Sure.
Can you do that while they're leaving? It doesn't matter. Well, could you? Don't expect the unreasonable. Some people do, but I don't. Oh.
Yeah. You want all of them, all. In a particular way with the alternates?
No, they can, no.
They can sit anywhere.
Oh, yeah.
They can sit anywhere. All in. Okay, come on in. That's all right for the jury, please.
Counsel approach.
All right.
I said an or instead of an and. So now I'm going to say and instead of or. So I have to give you a little bit of a clarifying instruction. In the charge, probably 2/3 of the way through, I gave you the definition of crime. I explained that to you. So let me clarify this to you. The defendant is charged with a crime against the laws of the state of Georgia. A crime is a violation of a statute of our state in which there is a joint operation of an act or intention to act and intention or criminal negligence. So that clarifies the charge. Now, it's time for y'all to go home. I promised y'all 4:30. It's after that, and the time to get going. I've still got to do some more work with counsel before I can give you the evidence anyway. So there's no way you can get started right this minute because we're not prepared for that. We have to go through and make sure all the evidence is in proper form to come to you, and that's just going to take a little bit of time, and it needs to take its proper time. It does not need to be rushed, but y'all don't need to be sitting around waiting. I'm going to send you home. I want you to leave your notebooks in your jury room. I want you to keep an open mind. You are not to talk to anyone about the case or let anyone speak with you about the case. Avoid any exposure whatsoever to media coverage. You are not at liberty in any way to do any independent investigation of this matter electronically or in any other means by which you could possibly think of. You know you're not supposed to do that. I did also want to give you one instruction about the alternates and the other jurors. The time that you are to be totally separate and apart is during deliberation. When we have breaks, y'all are going to, when you have a break, and when you start deliberating, Your foreperson will help you all and lead the decision about when to take breaks, that sort of thing. I'll probably say when y'all will have lunch. But when y'all want a break, then you would knock on the door and the bailiffs would assist you there. During breaks, all of you can be together. And during lunch, all of y'all can be together. But other than that, the alternates are to be separate and apart. So it's very important when you are all together that there be absolutely no deliberation or discussion of the case. It has to be break time. You're like me, when you quit working, you never do. You just keep right on working. Well, be like normal people. Don't be like me. Be normal. Quit working. Quit working, take a break, have your lunch, enjoy each other's company. Quit working, take your break. Do whatever y'all normally do on your breaks, because I know you're not discussing the case. So you all, when the 12 of you are deliberating in your jury room, only those 12, but when you have your lunch and when you have your breaks, then you can be together, but you must be vigilant and observant not to discuss the matter at all in any way during those times that you're all together. And finally, have a pleasant evening. Yes, sir? Council approach. I'm going to do it again. This time I'm going to do it right. I hope. So let me go very slowly, deliberately, methodically, and hopefully correctly. The defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of our state in which there is a joint operation of an act or omission to act, and intention or criminal negligence. We deserve to laugh. Y'all can laugh at me. I deserve it. It's been a long day for all of us. I do want to take up one other bit of housekeeping. We had discussed breaking at noon so you all could vote. And I know that one of you has an appointment that is important, but that person is the alternate. If you would like to take a little bit longer lunch to vote, and then come back and work in the afternoon. That is an option to you. There may be other plans that haven't been made, and I do not know. I would like, if you wouldn't mind, for you to go back in your jury room and write down a little note to me about what you would like to do tomorrow. Because, of course, we'll come back at 8:30 in the morning and proceed with you all getting to start with your deliberations. But the question is, would you like to come back in the afternoon, the 12 of you that are the working jury? Of course, the alternates would need to come too, and we'll accommodate the need of the one that I've already taken into account, the appointment that's important. I just need to know from you all what you want to do about that. I'll go that way.
All right. I got all your car keys. We got a set of keys downstairs for somebody. There we go.
Doing that so quickly. Thank you all for catching that. I appreciate it. In terms of the written charge to them, we've got to do two things before we break. And one is we have to clean up this about what to give them in terms of the written charge, and the other is we have to go through the evidence and get it together to go to the jury. I believe it's in pretty good shape for y'all to go through. It's well, knowing the clerk, it's in good shape. Why don't y'all take a minute and start. I thought so too. Why don't y'all start going through the written charge and start making your handwritten notes on it. Now, one thing we could do is what I originally wanted to do is all the deliberation stuff. These are my pages 19, 20, 21, and 22. And I don't know what they're going to correlate to. But right after, Mr. Sharon. Okay. Is that just one, or is that all of them? They want to work for half a day tomorrow. All righty. Tell them I said good evening. And we'll see them at 8:30 in the morning. But that was the reason I didn't want to give them the sympathy and prejudice, sentencing responsibilities, deliberation, note-taking, unanimous verdict. I don't know that they need to have that. It's pretty within the norm of what people understand jury service to be. On the other hand, I articulated that they were responsible to find guilty or not guilty as to each count, and that may solve the concern you had. On the other hand, Mr. Lumpkin, I don't know. It's going to be pages and pages and pages of, frankly, duplicitous stuff. Duplicitous stuff. Anyway, just some thoughts. I'm throwing them out. Have y'all had a chance to go through it, make notes yet?
Judge, I found three minor changes. I've shown defense counsel that. I'm prepared to give you my copy. If you want me to make a record, I can, or I can just provide a copy.
I just want to hear what they think about your three minor changes.
These are very good changes that I believe match what Your Honor noted as you were going through it. Caught yourself so you did not say the words and have those need to be added. So we're in agreement.
Okay. Yeah, the mental thing, I saw that. Yep. Okay. What do you have, Mr. Blanca?
I had the same thing that Mr. Evans found.
Do you have anything else? Okay, again, we can add those in. Then we should have that in the morning ready to go to them. Anything else in terms of the charge or the written charge to the jury for the state? For the defense?
Nothing further than reserving all of our previous objections.
I'll reserve all the previous objections. I'll note your exceptions to the court's rulings, particularly for the defense. Do you want to come forward and start putting evidence together, gentlemen? That means move.
An invitation or a command?
Well, usually when I'm inviting, it's a command. Haven't you noticed?
We shall.
I'm grateful. Brian, do I have the original verdict form? You have it? Okay.
Last page, I don't know if I left it on the copy or what.
Mr. Reynolds, it's good to see you.
Ma'am, thank you. Good to see you too.
You heading your way back?
No, ma'am. I'll be here through the duration.
Oh, will you? Good to have you. Those published this afternoon so they can look at them.
I heard when you said Mr. Reynolds, so
Oh, yes, that's our district attorney's here. Then before you type up, print out all of those, just get one for them to look at. We don't need to kill any more trees. Right, take it. Y'all too tired? Do you want to come back at 8 in the morning and do it? We kind of... Yeah, like sort of do it about as best you can, but then come in when you're closed. Being a slave driver? Yes, I do know that. You did good to get the and out of me, because guess what? It would have been a slip of the tongue and I would have been fine. Just do what little you can. I know you're tired, and I'm not going to hold you to say anything, no or no, because Carlos is working, and you're not going to get to leave anyway. Are y'all all in one car? Do you see your stuff? All my kindness is good for naught. Extra hours.